the first element that I want to talk about is this idea of mistrust, and I want to connect that to one of the most important principles in the work that we do at BLAC. So from the very beginning, when we meet with a client, we believe our clients, and we tell them that. We understand that by the time they get to us, they may have told their story countless of times to different people who they reached out to for help before getting to us. We also understand and recognize the exasperation in their voice once they get to us as they recount their story. You can hear them sort of underlying and highlighting the subtle elements of their story, which they seem to anticipate being questioned on, perhaps because they've been questioned before. So we say to our clients at the very first intake, we believe you, we see you, we're not doubting anything that you have said to us. I think this belief is so important because that sets the groundwork for establishing a trusting working relationship. So to go back to my story for a moment, there's the thing that she said. I won't say it here, but it was really unkind. Anyone who I've revealed what the therapist said to me has literally gasped with shock given the context of the situation. While I won't say what the word was, I will say that it was a stereotype of Black women. It rolled off her tongue without a pause. She probably believed it was a reasonable thing to say, and I don't think she meant any real harm by it. She realized, though, when I got up to leave, that she'd said something out of turn. The impact of the statement was so powerful that I couldn't stay in the room with her for another moment. The impact of the word on me was profound. Next slide. So that's another element of our work at BLAC that I'd like to touch on today, and that's the impact. The impact is the most important thing. It's not the intent of the person who is, or the institution who is inflicting whatever it is on an individual. Next slide. To end the story, eventually this therapist did call and apologize, but at that point the trust was broken. I mentioned this story to many people at the time, my family doctor, a member of my family, one of my high school teachers, and no one suggested taking any kind of action. Maybe they didn't know, or maybe at the time anti-Black racism was so subtle because we as Canadians were still living under the guise that we're too polite to be racist, that no one thought that my therapist meant any real harm because she'd apologized, right? We do live in a time now in 2022 where generally people have adopted the language of systemic racism. They're willing to acknowledge that anti-Black racism exists and that it's pervasive, but there still seems to be this reluctance to take the next step, which is to say that this person or this organization, this manager has engaged in discriminatory behavior or differential treatment on the basis of racism. I recently heard someone quote or read an article or mention something along the lines of a racism happened, but nobody did the racism. So we really have to be willing to take that next step to name it so that we can face it. Next slide. So before I move on, I'd like to thank Yodit and Marian, Elsie Dixon, Nicole Guthrie, and John No for their presentation a couple weeks ago. We thank them for taking their time to share their expertise with us and would like to share that we've received positive feedback from attendees on the substance of their presentations. So while I'll be talking about some case law a bit later, they will mainly be cases from the HRTO and the criminal justice area because our presenters did such an amazing and thorough job looking at different examples of poverty law in our last session. If you haven't checked it out, please take a look. I think we're going to be posting it on our YouTube channel soon, and then it will be on Knowledge Now. And it's just jam-packed full of information. Okay, so just going back to this idea of impact. So we talk a lot about providing trauma-informed services in order to provide more person-centered services. So while I'm not a social worker or an expert on this, My understanding is that trauma-informed services seeks to acknowledge the role that trauma plays in our clients' lives and the impact it has on their well-being, and to provide services without re-traumatizing the individual. In our work at BLAC, we have been aiming to take this one step further and to look at our services through a racial trauma-informed lens. The impact from both individual and systemic racism is real. The psychological and emotional pain from the incidents is passed on to family, friends, and the larger social group, and intergenerationally. So Khaldah is going to talk more about microaggressions later in the second half, but we need to keep this idea of the racial battle fatigue in mind when clients come to us for assistance. Clients may be dealing with what's referred to as race-based traumatic stress, and the mental and emotional injury caused by encounters with racial bias and ethnic discrimination, racism, and hate crimes. Next slide. So there was a recent study conducted by Dr. Ingrid Waldron, an assistant professor at University of Dalhousie for Across Boundaries, to look into the social reality of the clients they serve. Specifically, the work looks at the impacts of life events, stress, and discrimination on mental health. The research report examines trauma as it relates to experiences of psychological and physical torture. It also seeks to acknowledge the full breadth of the trauma experience, to include the emotionally and psychologically destabilizing experience of migration, settlement, and discrimination for migrants and Canadian-born racialized groups in Canada. The main clinical aim of the study was to identify how mental health professionals can more effectively respond to the complex experiences of racialized groups in Canada. But I think it's also helpful for us to consider as caseworkers. Next slide. So the key recommendations were that mental health providers who deal with racialized groups should understand the impact of racism on health. And I think the same is true for us as caseworkers, no matter which area of law we work in. I'm just going to share, so there are a few recommendations here, and you can go through them, but I just wanted to share an example of the impact of racial trauma by talking about some of our education files. So we recently conducted special intake days for a school board in Ontario, where multiple families had reported instances of ABR in their children's education. So the parents had been advocating for a long time for change, but they had been met with a lot of resistance. So my colleague and I spoke to parents who gave us a very long history of what their child, and many of them actually their children, had gone through. Some kids were called the N-word at school by other students. When they complained, their parents were asked by the school administration, you know, what do you want us to do about this? They weren't met with any solutions. One child was forced to hide from another student in class who was sort of fascinated with her, but whom the teacher couldn't control. So instead of dealing with him, who was a white child, the teacher opted to have the Black child like hide in a locked room for long periods of time. The stories are endless, but what all the kids in this particular intake group had in common was that after experiencing this kind of racial discrimination and harassment throughout their primary years of education, they all were dealing with mental illness, with anxiety, depression, PTSD, and each parent could pinpoint the breaking point for their kids in the moment when they began to change. So when I'm talking about impact, this is the kind of thing that I'm talking about. This experience of multiple, the experience of multiple experiences of racism is often true for our clients. Just another example that came to mind is a client who went shopping at a big box store and was asked multiple times if, actually when he got to the store, he had a bag with him, and he, because he's, you know, been asked many times when he's shopping if he has shoplifted, he went to the store security when he first got there and said, "Can I just leave my bag at the front?" And they said no. Ultimately, he was given a sticker to put on his bag to sort of like keep it closed. He did a shopping, and lo and behold, as he was checking out, he was asked if they could search his bag because they believed he was shoplifting. So that's a person who had experienced multiple experiences of racism and actually just has to navigate the world with the assumption that something like that is going to happen. Next slide. Oh, sorry, can you go one slide back? Sorry, one slide back, yeah. Okay, sorry, thanks. So just some of the recommendations. So like I said, understanding the impact of racism on health. I think it's important for us as caseworkers to understand that when we're working with a client who has experienced racism, that even if that particular event that they're telling you about may seem somewhat innocuous, to realize that this might be the 100th comment that this person has heard, or it might be the breaking point, or might have a bigger impact on that individual than you might realize or even understand initially. It talks about, one of the recommendations was that staff be culturally competent. Obviously, this is something that clinics are working towards by doing this kind of training. I also believe, like I said last time, by like reading, by being open and curious about other experiences on how to conceptualize discrimination as a form of trauma. It also recommended how to acknowledge the existence and reality of racism, which, as I said before, you have to name it, you have to see it. Sometimes it helps in an interview if there is a subtext of racism to be comfortable with actually saying it. If a client is telling you about experience and they're telling you about something someone said, but they're being somewhat vague, ask the client, was that person white? Was that person Black? Like, actually bring those issues forward, because it helps to provide, I think it helps to build that relationship of trust for a client to know that they're allowed to talk about race. And it also just gives them an opportunity to articulate something that might be difficult to articulate if they're unsure how the person they're speaking to will, if the person they're speaking to is receptive to these ideas about race. Okay, next slide. Thanks. So another thing that we've been thinking about at BLAC is not just talking about trauma or offering trauma-informed services, but how can we also explain to the tribunal, to the Human Rights Tribunal, or to the police if we're doing an OIPRD complaint, the impact of trauma on a client's ability to remember. So this is an example of a paragraph we've added to a Human Rights Tribunal application to just sort of flag, just from the very beginning, the possibility that an applicant might not be able to remember everything, especially given how long it's taking right now for hearings to happen, from application to a hearing. So talking a bit more about like what it means if a client has PTSD, if a client has depression, if they have anxiety, how that might have an impact on their ability to recall details, and to encourage the tribunal to consider these the impact ability in the hearing format. Next slide. Okay, so I'm going to change gears now and talk a little bit about some recent cases and decisions in the Human Rights Tribunal related to ABR. And I'll talk about our process at BLAC and how we work with clients to build a case at the Human Rights Tribunal. So as I said before, building trust is the most important thing. So we also try at the very start to get a sense of what the impact of the experience may have had on the client. So we ask the client at the beginning for any evidence that they might have. And often clients don't have very much, but we need to remember that the client's testimony is also evidence. So in terms of impact, there might not be a medical report or a letter of support from the therapist, but the client's evidence of impact is also still really important. So in the context of, for example, a social benefits tribunal hearing or a landlord and tenant board hearing, where a client has experienced some ABR and the caseworker is trying to get that idea across or trying to understand what the impact was. Some kinds of, we find sometimes that clients have trouble answering this question. So I like to break it down for them. How did this impact you emotionally? How did it impact your social life? What are the things that you used to do that you can no longer do? Who did you talk to about this? Why did you talk to them about it? How do you feel when you walk by the location that this occurred? For example, if something happened at a grocery store near their house. So these are the kinds of questions to ask to get to the heart of how an experience of anti-Black racism may have impacted a client. So an example of this is in Wickham, the Hongxi Chinese restaurant, and it answers the question of what do you do where there might not be a lot of, reports or documents to talk about this impact. So the client gave a very detailed explanation for how the experience of discrimination impacted him. If you're not familiar with the case, I'll give a very brief summary. So this case was brought by the applicant. His name is Mr. Emil Wickham. He was a young-looking 31-year-old man who identified as Afro-Caribbean. And to celebrate his birthday, he went to this restaurant in downtown Toronto with some friends who were also Black. He and his friends were directed to pay for their food before they actually received their food, and they were the only patrons who were asked to do so. They'd never been to this restaurant and asked the server who directed them to pay in advance if this was their policy. And they were told, yeah, it was their policy, so they paid. However, Mr. Wickham wasn't quite comfortable with being asked to be paid, wasn't quite comfortable being asked to pay before his food was served. So he went to some other tables and asked if anyone else had to pay before being served their meals. He went to 3 different tables and all 3 tables said no. So he went back to his table and asked the server why they had to repay. And the server agreed that they were the only table that had been asked to prepay. The server asked if they wanted their money back. And then I believe a manager came over and asked what was going on and seemed somewhat dismissive of the requirement to prepay and once again just offered the money back. So some of the arguments that the applicant made was that, like as a young looking Black man, Mr. Wickham was stereotyped in this situation as like a Black person is criminal and was like racially profiled. And while I won't get into all of the details of this case, I primarily wanted to focus on what he talked about in terms of his impact. So go to the next slide. Also, I'm so sorry, I did this thing with these slides, which I know is against the rules with slides, which was to put lots of information on all the slides. But I thought it would be helpful to have as a resource. I often go back to slides when I'm like working on cases, and it's handy to have everything in the same place. But I apologize for a slide like this, where there's a lot of text. But I think it's really interesting. So I'm just going to read what he said. He testified about the impact that this experience had on him. The racial makeup of Trinidad is approximately 40% Black, 40% East Indian, and 20% people of mixed ethnicity. Consequently, he says that his lived experience is such that he did not encounter a great deal of anti-Black racism prior to coming to Canada. He testified that he was not used to being treated like a second-class citizen because of his race, and was not accustomed to having negative behavior being attributed to him given his skin color. I have to say that this is something that we do hear from a lot of clients who are surprised by like the racist experiences that they have in a place like Canada. So Mr. Wickham also testified that he and his friends felt some sense of hopelessness after they left the restaurant, as there was little that they could do about the incident, and that frustration was exacerbated by the fact that they were aware that any displays of this frustration was as such as swearing would feed into stereotypes of Black people. So I think that this is like a very good example of an expression of the impact of anti-Black racism. Sorry, and something, sorry, just 1 second. Sorry about that. I'm not sure where my voice has decided to go today.
No worries. It's all right.
Hopefully you can still hear me okay.
Yeah, you sound fine.
Okay, thank you. Okay, so I will talk about another case now. If you can go to the next slide. Okay, so the other thing we do when we first get a new intake is we ask if there was an investigation. If there was, we'll ask for a copy of it and we'll take a look at it and see how thorough it was. If there wasn't, then we'll write the respondent and we'll ask for an investigation to be conducted and for the organization to preserve whatever document or evidence that they might have in relation to this. Often in shopping cases where a client is stopped at the entrance of a store and told, for example, that they have to leave their backpack at the front, or they're asked for a receipt on their way out of the store after paying for their items, a manager or an employee will often cite a policy that they're relying on. So we'll also ask for a copy of that, although there rarely is one. So when we look at the investigation, we look at whether or not the investigation was thorough. It will probably not surprise you to hear that they're often not very thorough. And in that case, when we file the claim at the HRTO, we'll challenge obviously the initial act of discrimination and also the subpar investigation as well. So just a couple of cases that address the issue of investigations and the thoroughness of them. The first one is Peterkin versus TD Bank. This one is from 2019. So this was a complaint that was actually filed with the Human Rights Commission. And the commission basically went through its standardized process. It conducted an investigation and which basically led to a report, an investigation report, and the commission essentially decided not to refer this complaint to the tribunal. Okay, so the federal, because it wasn't referred to the Canadian Human Rights Tribunal, the applicant did a JR on that decision. And the federal court found that the Canadian Human Rights investigation lacked thoroughness. It failed to consider obviously crucial evidence, including the follow allegations of a negative treatment. So this was about a client, an applicant who went to the bank to withdraw some funds of her own money, and she wasn't, her case was flagged, or her withdrawal was flagged. She was asked for ID. She had many different pieces of ID, and they still wouldn't give her the money. I mean, ultimately they did give her the money, but in the process of this, she was screamed at by a bank manager. She was spoken to in a demeaning manner. She wasn't granted the privacy. These discussions were held in front of other customers. At one point, she was forced to wait outside in the rain with the police for 2.5 hours. And when she called the supervisors at the TD office and branch office, they refused to speak to them. So the court found that this investigation, the investigation that the commission did, failed to consider this obviously crucial evidence. And I have another example of a case like this where the evidence for the investigation was not thorough. We go to the next slide. Can you go to the next slide, please? Okay, sorry. So this is Nasia and Peel Service Board from 2007. So in this case, the Peel police were contacted to investigate a possible shoplifting allegation at a large department store in Mississauga. And the tribunal found that the applicant had been wrongly apprehended by store security on suspicion of stealing a low-priced item despite her repeated and impassioned denials. The tribunal further found that a police officer conducted a discriminatory investigation that included stereotypically assuming that a Black suspect might not speak English, assuming that the white security guard was telling the truth, the Black suspects were not, without properly looking at all the evidence, including a videotape of the alleged theft, which exonerated her, adopting an assumption of guilt approach to the investigation by immediately demanding that the applicant produce the missing item, unnecessarily arranging for a second body search after the first one had demonstrated that she had not did not have the allegedly stolen item, and continuing with the investigation rather than releasing the applicant after the second body search confirmed that she did not have the item. So this is the kind of these are the kinds of investigations that we sometimes come across with our clients, and so it's really important that we challenge the investigation. Just because an investigation was done and not found any wrongdoing, if you start to look at the investigation and sort of take it apart, you often see that there is some amount of like differential treatment within the actual investigation, and that within itself can be challenged. And I'm looking at the time and I'm like, how did it all go by so quickly? If you could go to the next slide, please. Okay, so okay. Right. So I wanted to talk a little bit about evidence, because that's obviously the next step in the process. So we've had the intake, we ask for evidence, we talk about how the experiences impact the individual. We'll start looking at whether or not there was an investigation. And then we're looking generally at the evidence that a client may or may not have. So, this is always a tricky situation. A lot of clients don't feel like they have enough evidence, or if it's an employment situation, they might not have access to the documents that they had, or they may not have access to things anymore. But we do explain that circumstantial evidence is accepted by the tribunal, as highlighted in this case here. So where there's no direct evidence of discrimination, the question to be asked is whether the inference of racial discrimination is more probable than the respondent's explanation. And the first part here talks about the question of whether a prohibited ground is a factor in the adverse treatment. The adverse treatment is a difficult one for the applicant. Respondents are uniquely positioned to know why they refused an application for a job or asked the person for identification. In race cases especially, the outcome depends on the respondent's state of mind, which cannot be directly observed and must always must almost always be inferred from circumstantial evidence. The respondent's evidence is often essential to accurately determining what happened and what the reasons for a decision or action were. So even though there might not be something like that smoking gun piece of evidence, we still have to look at circumstantial evidence and push the tribunal to accept that kind of evidence. We are seeing a trend recently with the tribunal sending out notice of intention to dismiss. And a lot of these cases are cases where the applicant is relying on circumstantial evidence. And so we are, pushing back on the tribunal, just being like, this is the law. You're allowed to accept this kind of evidence. You have to accept and consider this kind of evidence. And that's, we're going to see how this goes over the next few months as we have these, as we get these decisions back and have some summary hearings as well. So other than documentary evidence, BLAC has also been pushing for the use of cultural assessments in sentencing. I'll speak briefly about Morris, but I will also direct folks to the recent training that Nana Ganfield did with advancing systemic racing arguments in immigration enforcement proceedings with the Refugee Law Office. That was great. There was also the Scarborough Community Legal Services Black History Month panel, recognizing the effect of anti-Black racism in our justice system, in which Nana expanded on Morris and R.B. Lee. And actually, given the time that we have, I might not actually be able to get too much into this, but the argument here is that the court, the criminal court should, you can go to the next slide. So this is a case of a young man who was convicted of various firearms offenses, and during the trial, his sentence was reduced from 15 months to 12 months. And one of the factors for that that the judge took into account was Mr. Morris's background and the impact of anti-Black racism on his life. And the Crown appealed this sentence and argued that there was an error in considering the social context evidence of racism. Next slide. So we intervened and made all these great arguments here, which I will allow you to go through at a later time. But one of the main arguments that BLAC was making was that judges must consider anti-Black racism and its impacts every time. Should consider anti-Black racism, especially when dealing with alternatives to incarceration, and should not make social context reports mandatory unless funded, and should not require that the authors of the reports be qualified as experts, and should apply social context evidence to determine whether something increases or lessens the severity of a crime. So the court ultimately did recognize the pervasiveness of anti-Black racism in Canadian society and the reality that it affects all social institutions, including criminal justice systems. Next slide. And we'll jump ahead to one after this. Okay, so this is what the Court of Appeal held. I think this ruling is helpful to use to argue the importance of social context evidence. This kind of report or evidence, like this, it can be good, I think, in many different contexts, but especially like in the housing context, if there's an eviction, especially if it's for a legal act. This is the kind of evidence where we might provide as caseworkers, almost a Section 83 evidence as housing. But if I think if we think about this from an ABR perspective, that we can move things along much further and push the law ahead. So this kind of social social science or social context evidence or cultural impacts is something that BLAC has been working along with the Social Assistance Action Committee. We've been working on drafting an affidavit that outlines the obstacles that BLAC people face when facing healthcare in Ontario. So there are many barriers to entry, including cultural, social stigma, fear of repercussions such as CAS involvement, and even fear of medical racism. So we've approached several specialists to work on this, and there's been some interest, but we haven't really gotten firm commitment yet. But I think this is the kind of affidavit that once we have it, that we can share with clinic caseworkers to submit as evidence in ODSP cases when you're pushing back on the DAU when they argue that an appellant isn't fully impaired because they haven't sought therapy, for example. I will also just mention here that I did a search on CanLII for cases at the Social Benefits Tribunal with the phrase anti-Black racism, and there were actually like 0 cases that came up. When I put in the word racism, there were about 10 cases that came up on CanLII. And most of them were talking about like an individual who's applying for social assistance who had experienced some racism, like in, like a country that they immigrated from. There was one case where there was a mention of racism, and there was an affidavit put forward. This was actually an Indigenous client. So there was an affidavit that spoke to the difficulty in accessing medical resources in rural communities. And the tribunal sort of said, yeah, we understand that this is an issue in rural communities, but this client didn't live in a rural community. And so basically denied the application or denied the appeal. So when we're thinking about using these kinds of like cultural assessments or social science context or an affidavit, I think it's really important to make sure that they are as detailed and relevant to your particular client and not too general, because that will give the tribunal or fact finder an excuse to not take notice of that. Okay, so I have realized that I have a lot more cases to go through, but not enough time. So I'm just going to highlight a few points. If Khaldah, if you don't mind going to the next slide. So I'll highlight a few points and just encourage you to seek out these cases to look at them further. So JKB and Peel, this was about a 6-year-old Black child who alleged that she was subjected to differential treatment because of race when 2 police officers treated her in a manner that was lacking in the care and compassion with which a white child would have been treated by handcuffing and shackling her at school. Next slide. So the applicant put forward obviously lots of arguments, but also called an expert witness who talked about the increased likelihood that police will use severe force on people whom they perceive to have mental health problems. She talked about bias is not restricted to police, but it's universal. She also talked a lot about people who appear to be in crisis and who are Black are both subject to attributions of superhuman strength, and research has shown that Black children are perceived as less innocent than non-Black children and less need of protection, prematurely seen as similar to adults. So some of these arguments or some of this evidence I think would be helpful in obviously different contexts. It makes me think about like housing, where there's often an intersection between mental health and eviction. or landlords who are showing some sort of bias. Just a reminder to the tribunal that's not restricted to the police. And also, it also makes me think of like social benefits or cases with Ontario Works workers or ODSP workers, where there's some sort of a disagreement within an office, and Black people are treated differentially because they're seen to be like more aggressive in these kinds of situations. Next slide. And I think this is a really great quote. This talks about prejudice and stereotyping. The main part, to care when others are treated unfairly or in pain. For example, white perceivers are worse at recognizing emotions on Black faces than on white faces, and in particular tend to perceive Black faces as angrier than white faces as with comparable expressions. So just wanted to highlight that. If you can go to the next slide. And so the decision talked about the fact that the police handcuffed such a young child, and noted obviously that this amounted to adverse treatment. In this case, there was also an allegation. There's also a call made to the Children's Aid Society, and the court found that that call was made maliciously. That's also something we have been seeing in some of our housing cases, where a neighbor might be making malicious calls to CAS on a Black tenant. And we view that as a form of anti-Black racism, and ask of the landlord to, remind the landlord of their duty to address that kind of harassment, racial harassment within the housing context. Next slide. The tribunal highlighted the fact that even if there is some, if the appellant or the applicant in this case is engaging in challenging, and it says, or even aggressive behavior, that race can still play a role in the way that, in this case, the police decided to respond to those behaviors. So the tribunal referred to the case Sinclair in City of London, where the court said it's important not to simply assure, it's important to not simply assume that because Mr. St. Clair is behaving inappropriately, race played no part in the decision to call security. Racial discrimination is often subtle and can manifest itself through overreaction or a different response when a racialized person is involved in a situation that poses challenges for those in authority. Next slide. Okay, so I won't get into the next case, but I would encourage you to look at this case. The slides sort of go through the arguments that the applicant made and the evidence that was presented by the expert evidence, by the expert witness. And I think it's just another good case that has really strong arguments that can be used in different situations, and actually goes into some interesting commentary on the kind of evidence that the tribunal will accept. So just briefly, this case, there was a statement, a blanket statement made by this daycare about everyone in this daycare being afraid of these children. And the applicant brought forward some letters from some of the families and the children in the daycare. And often we say, in a housing context, especially, you need to actually have the witness there. They won't accept hearsay, or, you want to be able to cross-examine the witnesses. But in this case, the tribunal accepted the letters from the other kids and families in this daycare. primarily because the respondent didn't have anything to counter that other than this blanket vague statement. They didn't have any names, there were no specifics. So it was just, I think, an interesting case that looks at the different kinds, like how to get creative with evidence and with proving that sort of like circumstantial evidence that we talked about earlier. Okay, so I've talked for too long. I'm very, very sorry about that. And I'm going to hand things over to Khaldah again.
Okay, thank you, Piera. I think this just speaks to how much there is to discuss on this topic and how much more time we could probably spend doing trainings like this and speaking to folks about these issues. Okay, so since we are cutting it close on time, I'll try to keep my next section brief. This next section is focused on cultural competency and unconscious bias. And then I will also end the section with some recommendations for clinics. And then we'll have a discussion in the end. So, so these are guiding questions that I want to frame the next part of the conversation with, and hopefully also discussion afterwards. And presumably some things, I guess, some questions to keep folks thinking about after this training. I think this is part of the purpose of this training. So the first question is, in terms of providing services to Black clients and addressing anti-Black racism issues effectively, what's working in your clinic? What's not working? What changes need to happen? And finally, what resources do you need in order to make those changes? And I think this is just an important way for us to yeah, an important thing for folks to keep in mind. So I'm going to do the first, this is a little bit of an activity, but obviously we won't spend too long on it. Okay, so unconscious bias. So name the color. Not the word that it says, but the color. Okay, now I'm going to go to the next slide. Name the color again, and not the word. So pay attention, you'll notice that the color is different from the word. And in psychology, this is known as the Stroop effect, and it's the delay in reaction time between congruent and incongruent stimuli. So I'll go into a bit why we wanted to do this, and thinking specifically about where unconscious bias comes from, and particularly literally how our brain processes information. So we use different parts of our brain for different things. We use the front part of our brain, the frontal lobe, when we think about those we perceive as similar to us. And we use the back part of our brain, the most ancient part of our brain, when we're dealing with those we perceive as different from us. The back part of our brain is where we record anxiety, fear, vigilance, and other emotions. And studies also show that we have less sympathy to those who are different, and our brains may even register them as objects or things rather than people. And the prefrontal cortex lights up when we see someone as highly human, but it fails to activate when we dehumanize people. So I guess what we're trying to say is that there's a very real psychological and aspect of understanding what unconscious bias is, which I think speaks to the fact that we have to be aware of these things, and we have to recognize how it can potentially impact groups of people when we are potentially biased towards them, have specific perceptions, recognize familiarity or difference. So unconscious bias, it's important also to understand cultural homophily, which refers to our tendency to congregate with others like us. It reinforces assumptions about others, including stereotypes. It reduces opportunities to learn about lived experience of others, and increases positive exposure to counter stereotypes. It also perpetuates differential treatment and marginalization, such as in-groups and out-groups. So I'm sure folks have done lots of these kinds of activities in previous webinars, but this is a first set of photos. These are class photos of Ross Lembeck, Seth Gross, and Logan Ryan. They're wrestlers at the University of Ottawa. I can also tell you how much how much they each wrestle, and where they go to school, their extracurriculars, and so on. And these are mugshots of Quayne Crawford, Milton Whitehead, Quinton Eatman, and Curtis Johnson. I don't know very much about these men, but both sets of these men were arrested on or around March 22nd, 2015, facing charges of burglary. And on March 23rd, 2015, the Iowa Gazette ran stories about both sets of men. They provided information about the education and extracurricular activities and used class photos of the first set of people and mugshots and nothing else on the second set of people. And while we also think that this is something that may be specific to the United States, as we know and certainly have come, or people have always known, but I guess is more in the public consciousness, that this is obviously not specific to the United States, but also to Canada. So this is a mugshot of 25-year-old Simon Zergesi that CP24 posted online in January 2018. Interestingly, this mugshot appeared in a news story about Simon being fatally stabbed after being chased up Yonge Street by a group of men. On the same day, CP24 posted the following photo of a smiling Bruce MacArthur, the accused serial killer who at the time had been charged with 5 counts of first-degree murder. On the screen, you'll see sorry, not there. But basically, I think this also speaks to, as has been shown many, many times, the impressions that media leaves, the kinds of photos that are used, and therefore, I guess the conception of who is a criminal, who's not a criminal, who deserves to be criminalized. And even when somebody is murdered, that they would still be criminalized with the use of such a photo. So what is the impact of this bias? So this is a research study that was done on kindergartners and who is perceived as a troublemaker. Researchers from Yale asked 135 kindergarten teachers to watch a short video or to watch short videos in order to detect challenging behavior before it becomes problematic. They were asked to watch videos which may or may not contain challenging behaviors and press the enter key on the keypad every time they saw a behavior that could become potentially a challenge. Each video included 4 children, a Black boy, a girl, a Black boy and a Black girl, a white boy and a white girl. But there was no challenging behavior in any of the videos. While the teachers watched eye scan technology measured the trajectory of their gaze, and the researchers wanted to know when teachers expected bad behavior and who did they watch. And the result is that teachers look more at the Black children than the white children, and that they look specifically more at the African-American boy. And this brings me back also to one of the things Piera mentioned earlier about some of the cases that we've been hearing lately, particularly about anti-Black racism in the education system, and how so many children, so many students are facing anti-Black racism within the education system because of these systemic issues. And part of it is to do with the fact that teachers perceive young Black children as troublemakers. They're perceived that way and criminalized from a young age, therefore resulting in the kinds of issues such as over-disciplining or so on, that impact them later on and also severely impact them and traumatize them, like Pierre was mentioning. There's also an impact of bias in remembering facts and evidence. So participants in this study read 2 stories, a fistfight involving either William, who was white, or Tyrone, who was Black, and a termination of employment involving either Brenda, who's white, or Keisha, who's Black. Participant misremembered relevant facts, including false memories and in a racially biased manner. Those who read about Tyrone remembered 80% of the facts, suggesting he was aggressive, while those who read about William recalled only 69%. And some participants even generated false memories of Tyrone being aggressive. Participants also misremembered mitigating factors, and they falsely remembered Brenda, the white employee, being employee of the month 17% of the time, but Keisha only 10% of the time. They also falsely recalled Keisha receiving mixed reviews from supervisors. So these findings are consistent with what we know about memory and recollection. When we have a hard time recalling, We rely on familiarity and expectations to help fill in the gaps. We recall stereotype consistent information more easily than counter stereotypes, and more likely to generate false memories based on stereotypes. I also want to talk about perceptions of the justice system and ask, do perceptions of the justice system differ by race? I ask this because it's important to recognize that the client, when we work with clients, a lot of them have had, in addition to having faced a lot of systemic racism, they've also faced a lot of issues with the justice system, and because of the issues that Black communities and racialized communities face with the justice system, have also a different perception of the justice system than do white people, for example. So a report by the Canadian Association of Black Lawyers, Race and Criminal Injustice, an examination of public perceptions of and experiences with the Ontario criminal justice system, asked the question, how do the police treat Black people compared to white people? They asked Black people, white people, and Asian people, or a similar sample size of each group of people. And according to the Black people who answered the question, the answer is much worse. 53% of them, so more than half of the Black people asked, said that the police treat Black people much worse compared to white people. Whereas white people answered that at much worse at 20% and Asian people at 23%. Obviously all agreed that, or more agreed that Black people treat the police, the police treat Black people still worse than white people. And also the question was asked, who would get a longer sentence? Would it, if it were the Black person, the white person, sentenced to the same crime, would one of them get a longer sentence, or would they get the same sentence? So 79% of Black people answered that the Black person would get a longer sentence, 48% of white people answered that, and 56% answered that. Significantly more, or about half of white people answered that they would get the same sentence, whereas only 19% of Black people perceived that. So I guess this speaks to the perception of the criminal justice system. And while we obviously statistically know that there are systemic issues within the criminal justice system and that there is systemic racism in that way, the perception of it also changes, which I think speaks to how people are going to treat service providers or trying to access service providers within the legal system, such as clinics. So now I'll go into some recommendations based on what the Black Legal Action Center sees, what they see as effective recommendations. Yeah, I guess what we see as effective recommendations, both for addressing unconscious bias and also to make changes within the clinic system to better serve Black clients and to address anti-Black racism. So the first recommendation is building partnerships with other clinics and community organizations that work with Black communities. The second one is to ensure access to services and reduce barriers, for example, language interpretation services. The third is to implement strategies to reduce unconscious bias. And the fourth is collecting race-based data. So the first piece I want to mention, because I think as community legal clinics, the partnerships that we build with other organizations are really key and can be a very effective way for us to support our communities to better understand what kinds of issues people are facing and to address a lot of the kinds of, I guess, to have a better sense of what people are experiencing, where they're at. And the second one also to ensure access to services and reduce barriers. Piera mentioned some of the questions that people can ask during the intake process. Did the comment that was made, did it come from a white person, for example? But I think in addition to that, we also have to recognize what barriers make it so that a legal clinic might not be an accessible place, especially given what we know about the perceptions of the justice system or service providers in general by Black communities. Another key aspect, of course, is language interpretation services, because a lot of people, aside from being immigrants, and the need for language interpretation, which is a very important aspect of, the low-income clients that we're serving, but also ensuring that we're using plain language in our resources and our materials. So also, I'm gonna also add some strategies to reduce unconscious bias and talk about collecting race-based data. So these are some of the strategies. I'll just read them out quickly, and then we can go into them after, again, if people have more questions. So we can raise awareness, obviously, of implicit bias within our clinics, attending trainings, and that kind of thing. Identify and consciously acknowledge real group and individual differences, so not pretending that this is not a thing. So check the thought process and decisions for possible bias. So when decisions are being made within the clinic system, within the organization, check them for bias. Remove and reduce distractions and sources of stress in the decision-making environment, because information does show that when we're rushing to do something, when we have a lot of stress in doing something, we're more likely to act in that way. Identify sources of ambiguity in the decision-making process and establish concrete standards before engaging in decision-making. Institute feedback mechanisms so you can hear back about what is working, what isn't working, and actually listen to that feedback, and increase exposure of stigmatized groups, group members, and counter stereotypes, and reduce exposure to stereotypes. I think the last point also speaks to the importance of building partnerships and making those partnerships genuine. So it's not just about increased exposure, but rather about building connections. I also want to talk about race-based data and how we can identify it in systemic, and how we can use it in our practices and also use it to identify systemic issues. So race-based data, I think we've heard many times about the benefits of using race-based data and why it's important and why clinics should implement it in their practices. So it makes problems visible. It makes it so that racism is not just a thing of the past. We can see clearly the link between the intersecting factors and the situations and issues that communities face. In the beginning of this presentation, we mentioned some statistics, for example, the number of Black communities that are low income, the disproportionate rates. We use data all the time to describe the systemic issues, within the criminal justice system, within policing, within the child welfare system. We have so much data that shows and makes that problem very visible. It makes it so that it's not just about the individual perception. So it's not just about an individual thinking that the police is racist, but there's a lot of data to prove that this is a collective issue. And it also attributes the responsibility. So the institutions who would be responsible for the decisions that are leading to this, it's important to, I guess, identify these institutions and where these discrepancies and where the disproportionate rates are coming from. However, race-based data also presents some risks. So it can also be misused and misinterpreted. It could lead to racial profiling or feed stereotypes and prejudices. I think that most folks who understand that race, like we said, is a social construct, or what the process of racialization is, and so one wouldn't use it to mean that, well, there's more Black people in prison, therefore Black people are more likely to be criminals, but rather understand that it's a systemic issue where Black people are more likely to be criminalized as a result of racialization. But I also want to add that, systemic issues have been identified as we share all the time, all these statistics about these things. And I want to share this quote. So from an article by Ronaldo Walcott: "Evidence is important, and if you would dismiss evidence as unnecessary. However, race-based data can quite frankly slow down reform. In that context, doing the research when a problem is already identified and its solutions known means that the collection of race-based data does not actually add much to policymaking. In fact, in some cases, it can do more harm than good. Race-based data collection, as currently articulated, is a response to a set of political concerns masquerading as if it is the answer." And I will expand on that a bit by saying that the answer to the systemic issues that Black people or racialized communities as a whole are facing is not always to collect more data and provide more information and do more training and that kind of thing, but rather to make policy changes. And so at some point, the continued collection of data that proves the point may not be actually effective anymore, because we have, first of all, we have so much data that proves all these things, but is the data being backed up by policy changes? I think is a question that we need to ask. This is not to say that folks should not be collecting race-based data, but I think it's important to recognize what the purpose of that data is to make sure that it's being used effectively and that it's not just another way that, I guess, information or something is being extracted from folks. So I'm gonna go back to these guiding questions, which asked us, in terms of providing services to Black clients and addressing anti-Black racism issues effectively, what's working in your clinic? What's not working, what changes need to happen, and what resources do you need in order to make those changes? And this is the case study that Piera mentioned last time that we also sent out in an email, so I'll read it out again. An elderly Black tenant from the Caribbean is facing eviction from her subsidized unit for hoarding. By the time she comes to you for help, she's already had extreme clean come to her unit. She has had a broken and mediated agreement. The client tells you that her living room is full of barrels and that she wants to send home tubs of coconut oil and clothes she needs to organize to put in the barrel. She moved it into 1 bedroom from a 3-bedroom house. She has back pain and she's on ODSP. She tells you that the first time Extreme Clean came to her unit, they threw out a bucket of her coconut oil without asking her, and that she was reluctant to let them in again. Keeping in mind the rules we just went over, keeping in mind the rules we went over during our last training, how can you advocate for this client? What arguments can you make at the LTB? And I guess this is food for thought for the rest of 5 minutes that we have in this presentation. I don't know if Piera has anything to add on this.
Yeah, I'm just wondering if anyone has any ideas, if they can put it in the chat or the Q&A about what kinds of arguments that they might make for this client, or even to answer some of the questions that Khaldah put up on the screen before. Or if anyone just has any general thoughts, you can feel free to share. I note that Paul Pickerton put a note about the training, the refugee law office training. So that can be accessed on Aleo Law, which is accessible from the source on the video and training session library page. It's not cross-posted on the on-demand learning library. Does anyone have anything that they want to add, or?
I guess if folks don't have anything to add, we'll keep our lines of communication open. Folks can obviously access the Black Legal Action Center and get in touch with us at any time to discuss this, to discuss issues that their clients may be facing, or any community development work that they're working on as well.
Yeah, and we talked a little bit in the last session about reaching out to BLAC if you have a case, either where you want to do a case consult, or you want to talk about the arguments that you can sort of develop, and we can sort of work together on a case. Feel free to reach out to us. We're happy to talk. I have had lots of calls recently from different clinics, and it's really nice to not just, it's obviously nice to be able to work together, but it's just nice in COVID times when we haven't seen each other for a long time to be able to connect over the phone about our cases. So I don't know, maybe Khaldah, you want to launch the poll, and if anyone has anything to add, we'll sort of just be around for the next few minutes.
I am about to launch the poll. If people
Okay.
just hang on one sec.
Okay, great. And otherwise, we'll just say thank you for joining us today. If you can take a look at the poll before you log off, that would be very helpful. It's good to get feedback. And we appreciate you taking the time to spend time with us for the last hour and a half.
Thank you all so much. Take care. Have a great rest of your day.
Thank you.